This conference will now be recorded.
All right. Again, good evening, everyone. Thank you so much for joining us tonight with the Oceanside Library. We are with Wendy Sheinberg from Rivkin Radler, Attorneys at Law. Thank you so much for being with us tonight. And just letting everybody know this program is being recorded. So if you turn your camera on, you will be in the video. So, all right. Without further ado, I'd love to introduce Wendy Sheinberg. Take it away, Wendy. Thank you.
Thank you. So we're going to have time for questions and answers at the end of the program. And I just want to explain the best way to ask questions so that your privacy can be maintained. This program is being recorded and there are other people listening and there are other people viewing it as a webinar as well. So if you have a question about the topics I'm discussing, the best way to ask it is to ask it in general terms without giving any personal facts, because other people are on here and it's going to be preserved for posterity on YouTube or for however long we have YouTube. So right now there's a lot going on and there is a lot to think about, and it's very hard to figure out where to focus and what's important. And I think a lot of us have a little bit of information overload where we're wondering, do I really need to take care of this? Do I really need to take care of that? And addressing estate planning is incredibly important. I think it's always important. And it's important for anyone who is over the age of 18. A lot of times clients will say to me, well, you know what, I'll wait, there's time. And my answer is usually, bad things don't operate on a schedule. They don't wait until it's convenient for something bad to happen. So what we want to do is make sure that we put together a plan that would reduce the impact of something bad if and when it happens. Nobody likes to think about bad things, but what I always come back to is, we make plans all of our lives, and even as very small children, we are taught to plan for the possibility of something bad happening. And I think of stop, drop, and roll. We're all taught this probably before kindergarten, and I can't really imagine anything much worse than catching fire. But we're taught this plan. If this happens, this is what you do. And the idea behind that plan is to mitigate the damage, to keep you from having a bigger problem if something bad occurs. And that's really what we're looking to do. Uncertainty is incredibly frightening because you can't plan for it. But one thing that I think is very important is not to plan out of panic. You will see a lot of advertisements, a lot of bulletins and emails from attorneys creating this grave sense of urgency that you have to do this now, you must do it. And yeah, I agree that it is time to do it. You don't have to come from a place of fear. It should be a thoughtful process where we really stop. We look at what it is that's in our lives, what it is that's important, and what we want to have happen. So instead of stop, drop, and roll, we're going to stop, think, and plan to make sure that we can come up with doing things the right way. Another question that I get from clients is, can I take care of this now and still be safe? Can I still observe the social distancing and physical distancing rules? Because I don't want to come into an office and risk getting ill. And the answer is you can. So we've had 2 executive orders signed that provide for the ability to notarize people's signatures by witnessing their signing through an audio-visual means, kind of like this, a live interactive audio-visual feed. And people are doing that now through FaceTime, through Zoom, through GoToMeeting, all these different platforms. And thankfully, we have an order that allows us to do that right now, and an order that also allows witnesses to witness documents, even though they're not in the same place as you are. Not everybody has a computer or a smartphone with a working camera, and colleagues of mine and myself are doing what we're calling drive-up signings, which there really is no drive-up window. I live here in Oceanside and I have a covered porch. I had a client who needed to sign something. I couldn't get to him. He didn't have internet. So I said, you know what, Danny, just drive by my house. I'll put 2 tables on my front porch. You can sign and I can watch you sign from my living room through the screen door. And we were able to make sure that he could sign his documents in a way that he was safe and that I was safe. So there is still a lot that we can do, and we can make sure that we're doing things in a way that is smart. Well, what we're really looking at in health and estate planning is making sure that you take care of you while everything is fine. And we're doing that with a view towards also making sure we can take care of you and the things that you own if you're not in control, if something bad were to happen. And then making sure that things are going to work the way you want them to work later on after you pass away. So the things that we need to look at are medical decision-making, financial decision-making, asset protection, and asset distribution. So if you couldn't make your own medical decisions, who could make them for you? And what kinds of decisions would those be? An additional component to that is who has the right to access your medical information if you can't tell anyone that it's okay to do that. So depending upon what's been put in place guides our answer. In New York, you have the ability to sign a document called a healthcare proxy. And that document lets you choose who will make medical choices for you if you can't make them for yourself. When I counsel clients, I usually suggest that they have an order of succession so that there is a primary agent. And if that person's not available, that there's a secondary person. And then if that person's not available, a third person, because sometimes people simply are not available. The healthcare proxy lets you say what limitations there are on care. It also lets you add additional provisions to it. This is a document that can be used to make medical decisions for you, whether you're at home, you're in a hospital, a nursing home, an assisted living, anywhere. It is not limited by the place that you're located. A few years ago, a law passed in New York called the Family Healthcare Decision Act, and that is what we call a default legislation. And this says that if you don't have a healthcare proxy and you don't have a guardian, and you are in a hospital or a nursing home, that certain people have the right to make certain types of decisions for you. The bad thing about it is it's guided by statute. And the people that the statute thinks should be making your medical choices might not be the people that you want to have make your medical choices. There are a lot of people who are closer to their families of choice than their families of origin. There are people that may have multiple adult children, and there is one kid that they want to have make the choice and another kid that is the last person on earth they would pick. And the statute doesn't give you the ability to pick and choose that way. So it's very nice that we have it, but it is incredibly limited, and only for the hospital or a nursing home, absolutely nowhere else. If somebody lost the ability to make their medical choices and they didn't have the opportunity to have a healthcare proxy put in place, in addition to the Family Health Decision Act, you can also seek the appointment of a guardian. So family members could go to the Nassau County Supreme Court and ask to be made the guardian to make medical decisions and other personal care decisions for the individual. The decisions that can be made under a healthcare proxy, Family Healthcare Decision Act, or a guardianship can be routine medical decisions, they can be major medical decisions, and they can also be end-of-life decisions. It's always best to actually have your own healthcare proxy in place, and I like to couple that healthcare proxy with a document called a living will, which outlines a person's end-of-life choices so that it's not left up to guessing and the family has some real guidance about what someone wants. An added issue with medical decision-making is access to medical information. And there are different standards of information that can be released depending upon who the person is. So you and I, as we sit here today, we have a right of privacy, our private medical information. And there is a federal law called HIPAA, HIPAA. There is New York State's public health law that governs privileged medical information as well. Underneath the healthcare proxy and under the Federal Healthcare Decision Act, the person that's acting for you has the right to medical information that the providers deem relevant to making a medical decision. That is not the same as all medical information. When I counsel clients, in addition to doing a healthcare proxy and a living will, I also counsel them to sign a HIPAA authorization that designates their healthcare agent as what's called a personal representative under the HIPAA laws. That way there's no limitation and the family members can get the information that they think is appropriate. Now, in the event that you're not able to take care of your finances, your stuff, we need to look at who's going to be able to take care of that for you. And who that person or people are is going to be governed in part by what kind of stuff we're talking about. If they're joint accounts, it's one answer. If it's other joint assets, it's a different answer. And if it's things that are solely in your name, yet again, a third choice. Well, if we're looking at joint bank accounts or convenience accounts, the individual who you've put on the account with you will be able to access that account and be able to utilize the funds in that account. Many times, husbands, wives, wives will have joint accounts that are meant to truly be joint accounts, where that money is believed to belong to both people equally for them to do as they wish. Other times, a person will put a child or another individual on their account, and they don't mean it to be a joint account. They're putting that person on the account for convenience purposes. I don't usually see bank accounts that are properly labeled as convenience accounts, and part of that is the lack of awareness that there are banks that will designate accounts in this way. So in the event that you have an account and you want someone to have access to it, but limited to it being for your benefit, you want to make an appointment with the bank manager, sit down and make sure that you can designate the account correctly and that it's going to be solely for convenience. The joint accounts, that there's really going to be no restriction on how it's used. If we're looking at joint real estate, that's going to be a different answer. So even though a married couple may own a house together as joint tenants or tenants by the entirety, the spouse who has capacity does not have the ability to manage the other spouse's interest in that property by virtue of the joint ownership. That account's going to be treated differently. And the person that would have the ability to address it would be a designated agent underneath a power of attorney who's been properly given the authority to address those assets. And in the absence of such a person, then a guardian of the property as appointed by the courts. In addition to jointly held assets, sometimes we'll see what we call tenants in common. And that can be a brokerage account or it can be real estate, where it'll have two people's names on it, but it doesn't indicate joint with right of survivorship. It's very important to look at the way that assets are titled and to get clarification from the brokerage house or the attorney who's drafted the deed to understand what is the legal ramification. If I own an account as tenants in common with my husband and I pass away, that account does not become his. He still has his account, his part of the account. The other part of the account is controlled by my will. If I meant it to go to him, then I really need to retitle that account. If I have an account of that type, again, it can be accessed by my power of attorney or my lawfully appointed guardian. And the same is true of assets that are in my own name. Whether I'm married or not, my spouse does not have an inherent right during my lifetime to access my assets. The only way we can make sure that these things are going to be managed is by having someone appointed to take care of them. We do this through a power of attorney. And the art of a power of attorney really is in the modifications. A lot of times people can purchase documents off the internet or in a stationery store, but these documents are going to be skeletons. They're going to have the bare minimum, and quite often the bare minimum is not what we need. So my view is that people over the age of 18 should have, in addition to their healthcare directives, the power of attorney that has modifications that are drafted for that person. And if you want your agent under the power of attorney to be able to use your assets for themselves or for others, this document must also include what's called a statutory gift rider, and that's the law in New York. If we want the agent to be able to make a gift to him or herself, it needs to be clearly indicated in the appropriate portion of the statutory gift rider. Now, usually it is the case that we want the people who we're appointing to be able to have the right to make gifts to themselves. So it's incredibly important that this appear within the document. If it doesn't, the person will not have the ability to do that. I also recommend to clients that we think about a worst case scenario. If my primary agent is unable to act, then we should be appointing successor agents so that they can take care of things. And this can come in handy whether it's a matter of somebody being mentally unable to address things, or even if somebody was ill and they were in the hospital and unable to take care of their bank accounts and pay their bills. We want to have a person that you trust have the ability to go in and take care of those things for you. And when we're looking at an estate, a lot of people say, I don't have an estate, I'm not Thurston Hell III. I'm Joe Smith, I'm a regular person. Well, an estate is not determined by how wealthy someone is. An estate is simply your stuff, your assets, the things that you own. And it's going to include your assets that you hold jointly with rights of survivorship, things that you hold as a tenant in common, assets that are just your name. If you have a home and you've given away part of it and retained a life estate, it will include assets that you have beneficiaries on, as well as bank accounts that may be labeled in trust for, or TOD, powers of appointment, and assets that you have in trusts. All of that comprises your estate. So a big question that I get from clients is often, well, why does that matter? And the wise guy mom in me usually likes to come back and say, because I said so, that's why. But there is a real reason, and the reason is because you love your family, and the way things are owned controls what will happen to those things. So a will generally cannot change joint accounts or joint assets. It generally cannot change contract beneficiaries or vested interests. There is one minor difference if you have a bank account in trust for someone and the will contains very specific language. That's the one beneficiary you can change through your will. And headaches happen when ownership doesn't match what the intention is. So if we have a situation where all of my bank accounts are joint with Colin, he's the happy looking kid in this picture, and my beneficiary designations all named Colin because Andrew wasn't born at the time, it doesn't matter that 10 years later I drafted a will that said split everything half and half between Andrew and Colin, because my will is not going to control. Those beneficiary designations are going to control, and Colin is going to run off and leave his brother very unhappy. And this is the law of unintended consequences. So being cognizant of the way that the assets are held and then taking that into consideration when we're drafting a will and possibly updating those is going to make sure that things go the way that we want them to. So people talk about wills and they talk about probate. And I'd like to really go to the basics and explain what a will is. All a will is a piece of paper that meets certain formalities. And it says where you want your things to go when you pass away. Your will can also name guardians of minor children. which can be very important. And it can create trusts for people that might be at risk, whether it's because they are financially not savvy, they're young, they have different problems where they shouldn't be managing their own funds. A will can take care of all of that. And I generally recommend that you have a lawyer draft the will, because the issues that we see when someone has a will that's been prepared by themselves, we don't see those issues until after the person's passed away. And once that's happened, we don't have the ability to fix it. And the courts are not going to entertain correcting it. Probate is simply the process in which the court recognizes that the will is the will of the person who signed it, that it's not the result of fraud or somebody forging a document. It's usually a very straightforward process for most people, especially here in Nassau County. And we'll hear a lot about avoiding probate. People who need to avoid probate generally are going to be people whose family may disagree with what their will says, people who have property in other states, or people whose beneficiaries may need immediate access to funds. So right now we are in a very unusual period for so many reasons, and particularly with the courts. For the most part, our courts are only entertaining what they consider emergency applications. So if a person were to pass away today, it's going to be a very long time until I can get their will probated and get access to assets for beneficiaries. So under the current circumstances, I'm leaning more towards people looking to avoid probate and try to make sure that people will have access to things when they need them. And there are a variety of ways that you can avoid probate. The one thing that you shouldn't do is to simply give all your money and your assets to your children or put their names on everything, because they will take it. And once it has your children's name on it, it puts your assets at risk. It's at risk of their creditors. It's at risk of their having a matrimonial problem, and you've now lost control. So you want to make sure that you have a real plan that's going to take care of you, maintain your independence, your ability to do what you want, and to have it done in a way that protects your dignity. So the options that we usually look at is either trusts or life estates. I'm going to start with life estates because those are simpler. A life estate is simply about real estate. It is a new deed that someone signs where they retain the right to live in their house for the rest of their life, and it goes automatically to the beneficiaries. We call them the remainders, who are listed on the new deed. It avoids probate. After 5 years, the assets are protected for Medicaid purposes, but I am generally not a very big fan of life estate deeds. And the best way to explain what's not great about them is through an example of Mr. Jones, who was neither a Mr. nor was his name actually Jones. So in 2007, a deed is signed from dad to the 3 kids, and dad retains a life estate. 2012, 5 years later, the house is fully protected for Medicaid purposes, and it's going to avoid probate when Mr. Jones dies. In 2018, one of his children passes away, and 2 years later, Mr. Jones dies, and the family calls me to review the estate, and they give me a copy of the deed, and they give me a copy of Mr. Jones' will. Mr. Jones' will says that I give everything equally to my 3 children, and if any of them pass away before me, their share should go to their children. So the question would be, who owns the house? And in this case, the house is not owned by the 2 surviving children and the deceased child's children. This house is now owned by the 2 surviving children, the deceased child's spouse, and a smaller interest to the deceased child's children, which is not the result that was intended. And it's not an unusual circumstance where it happens, but once you do a deed with a life estate, that's a vested interest. We can't take it back. There is no more control. So a better option would have been a trust. All a trust is an agreement that you make with a person you trust, and that person is called a trustee. And the agreement is a list of instructions about how they address the assets that are inside of that trust and who gets the benefit of those assets. There are two main types of trusts, and then they break down to so many other varieties. The main two varieties are revocable and irrevocable. A revocable trust is a trust that simply is set up to avoid probate. It is not for Medicaid planning. This type of a trust allows for ongoing asset management. If I set up a revocable trust, I can be the trustee of it, and I can use that trust for myself or for anyone else that I want, as long as I'm alive and as long as I have capacity. When I pass away, the trust has instructions for where assets go, who they go to, and how they get them. And nobody in my family needs to go to court to make that happen. It's already built into the trust. If I change my mind and I want to give somebody else a little more, someone else a little less, I can do that. I have the absolute right with one of these trusts to fully revoke it and change it. I can make it into a whole new document. I can name backup trustees to take over if I don't want to do it anymore. And I can make sure that life is going to go the way I want. If I have real property in another state, that's a perfect asset to put into a revocable trust. That keeps my family from needing to have a probate proceeding in New York, a probate in Florida, or whatever other state I own property in. Also, having a revocable trust right now would be a great thing, because right now we don't have full access to the courts, and it reduces the delay and allows us to have access to funds sooner. If we're looking at doing more, like Medicaid planning and certain types of estate planning, we need to be looking at irrevocable trusts. Depending upon the purpose of the trust will depend upon who can be the trustee and what the provisions of the trust would say. If we're looking at a trust to not only avoid probate, but also protect assets in a Medicaid or health care planning situation, then the person who's setting it up, that's called the grantor, cannot be the trustee. We need someone else to be the trustee. But the grantor retains the right to fire the trustee and replace them with anybody other than themselves. The grantor also retains the right to change who the beneficiaries are later on. Not all irrevocable trusts are the same. Not all irrevocable trusts are Medicaid protected. You really want to make sure when you're sitting down with the lawyer that we're focusing on what your goal is and then creating the proper document to help you meet that goal. So with this irrevocable trust, this would have given Mr. Jones everything that he had with a life estate and more, because what would have happened under the trust would have been what he wanted to have happen under the will, where the remainder of it would have been split between his two surviving children and his two grandchildren without having to include his daughter-in-law. Another issue that makes this preferable over a life estate is what happens if we go to sell the house. And with a life estate, if I go to sell the house, I don't get all the money. That money is going to be divided between myself and the other beneficiaries. Whereas if Mr. Jones' house was in an irrevocable trust, that money is going to come back into the trust and it's going to be there. So if Mr. Jones wants to sell his house in Oceanside and buy a condo on the boardwalk in Long Beach, all that money is still going to be there. And the primary residence exemption is going to apply to 100% of his ownership, which is going to be counted as his entire ownership. So you have a $250,000 primary residence exemption for capital gain, and he will keep 100% of that $250,000 exemption and not have to pay capital gain taxes during his lifetime. With these trusts, it's very important that the attorney that's working with you sits down and looks at all of your assets to determine what goes in the trust and what stays in your name or goes into a revocable trust. No one should ever have all of their assets put into an irrevocable trust because there are limitations to access, and nobody needs to have their access cut off to all of their assets. So we really need to make sure that we're looking at what a person's needs are, deciding what stays out, what goes in, and deciding who gets the income, because you can decide that within these trusts, whether the income goes to the person setting it up or if it goes to the beneficiaries. So the idea of an irrevocable trust can be a little bit scary because it's irrevocable. You can, however, revoke an irrevocable trust in New York, as long as you have the consent of all the beneficiaries. So if I set up a trust and I name our 3 kids as the trustees, I put the house in it, and a couple years later, I decide I'm going to go to Long Beach. I want to sell the house. And I tell the kids that I'd like to sell the house, and they say no. What can I do? Well, I can go ahead and change the beneficiaries. So I can use my power of appointment to change the beneficiaries so that my kids are now no longer the beneficiaries. And then I go to my new beneficiaries and say, I'd like to revoke the trust, and they say yes, so that I've still maintained a high level of control. These days, I see a lot of ads for do-it-yourself legal documents, and I think they make about as much sense as a home appendectomy kit. It's more than just typing a document and signing a piece of paper. There is years of experience, overlapping laws, different cases that control whether or not a document's going to work. And do it yourself can sometimes come at a terribly high price. So this is based on a real story. Another Mr. Jones purchased a famous TV spokesman's must-have document kit. It's advertised as having a $2,500 value, but it's a bargain for $99. And on every document in the program, it says this is not a substitute for legal advice. Have these documents reviewed by an attorney. So Mr. Jones goes, he buys it, he downloads it, he drafts his own will, he drafts his own trust, and he absolutely does not have it reviewed by an attorney, because it would probably have cost more to have it reviewed by an attorney than just have the attorney draft it. He signs his will properly, he signs the trust properly, but he doesn't put anything in the trust. He passes away, kids come in, he has a house, he has other assets, things in the trust, nothing has any beneficiaries. So we got, it's okay, he has a will, and the will is a special kind of a will. It's called a pour-over will. And a pour-over will takes the assets that are left in the person's name and distributes them to the trustee of their trust. Reading through the will, and I look up at the kids and I say, so how well did your dad know this famous TV spokesperson? And they look at me like I'm a complete and total moron. And they're like, well, what are you talking about? And the document does not say I leave everything to the Mr. Jones Revocable Trust. Instead, it says I leave everything to the famous TV spokesperson Revocable Trust dated blah, blah, blah. And we look it up because we know where this famous person lives, and there is a deed in the name of this person's trust. It's a real trust that exists, and it was the default language in the document program. Like, okay, well, this is clearly a mistake, and we call the surrogates court to find out what we need to do. And the answer was, you have to probate that will the way that it is. And you need to give notice to famous person and then see what you can work out. And ultimately, we were able to resolve it where a famous person waived any right to everything. But the legal fees that were involved in correcting this were at least 4 times the cost of doing it correctly at the beginning with a skilled and knowledgeable attorney. So it's definitely not a do-it-yourself project. What you want to do is put a plan in place now. You don't want to wait until there is a problem. You want to make sure that people are able to access medical information and make medical decisions. A big issue that's come up for people in the current crisis is that when somebody goes into the hospital right now, they're not allowed to bring someone with them because the medical providers do not want additional people exposed to the virus that's going around. And family members want to obtain medical information. Well, when you are checking into a hospital underneath emergency circumstances, you're generally not thinking about the papers that you need to sign and making sure that family members can have access to information. So it's incredibly important to have something like a healthcare proxy and a HIPAA authorization in place. That way the doctors and nurses can speak to your family, they can keep them advised of what's going on, and your medical decisions can be made for you in the way that you want. And to also have that power of attorney in place for the same reason. You know, we're in isolation and we want to make sure that people can be able to do things for us. A lot of people tell me that they don't need to plan, and I'll say, you know, my mom didn't have a will, we didn't do any probate, and everything worked out, and it's going to be fine. My family knows what I want. And I always say, okay, well, let's think back to when your kids didn't agree and how many toys were destroyed and how many tantrums there were. People generally don't behave better when their parents are not around. And it's a much better idea to have a plan that meets your wishes and says exactly what you want so that there is no guessing. You absolutely need to have a plan, even if you think it's going to be simple and nobody's going to complain. So I think we have plenty of time for questions. We had one person send in a question earlier, and I'll address that question first. This person has a life insurance policy through their job, and they wanted to know how they could change the beneficiary to be a particular charitable organization. And they're concerned because nobody's currently at their job that can make that change. So the answer would be that these policies are usually written through an insurance company. And I will tell clients, go online, find the insurance company's website, and they will have pages devoted to forms for changing the beneficiary. So this person is very smart to think about it now. I want to make sure that the beneficiary is this charity. If you find the insurance company, download the forms, you can change the beneficiary, and most companies will let you fax it back to them or email it back to them. And then you simply ask them to send you back confirmation that that change was made. Does anyone have any other questions?